Okay, Steve Vondran, we're back again, and we're finishing up on the writ of attachment, financial elder abuse under the Welfare and Institutions Code 15657. Okay, now, so we've talked about the complaint requirements, we've talked about the writ, the package you want to put together, we've talked about the types of damages you may be wanting to seek, your compensatory attorney fees and costs, punitives, so making sure that this is all reasonably quantifiable, not the pie in the sky. The judge is not going to let you attach property for $100 million because you have this pie in the sky concept of how you've been damaged. So make it reasonable, something that the judge can bite into, okay? Next section, and I'm going to switch to my blue pen here. Next section here is notice. What type of notice is required on these writs of attachments for your financial elder abuse cases? Now, one thing you can do is actually provide notice. You or your attorney can say, yeah, you know, look, we're going to be filing a motion for a writ of attachment, and you know, what's a good date for the hearing, and we're going to do it on this date, and so forth. You can oppose it. You can do your motions to oppose, and we're fine with that. That's the way it goes. And we'll reply, and we'll have the hearing. Okay, so you can do what we call a formal noticed motion. The time frames on that CCP 1005, we have a video on that if you need to know the time frame. CCP 1005 Vondran, you'll find that nice video for you. But you have your notice requirements. The beauty of financial elder abuse cases, the writ of attachment, the power of the writ of attachment is that you can do these ex parte. Ex parte. What does that mean? Ex parte means you can go in on your own without notifying any of the opposing parties. That's pretty powerful. In other words, if you get the notion one day, let's say, that the defendant is going to be concealing or hiding assets, you can go in ex parte. So find out when the hearing is, get in there, and this is without the other parties having the benefit of providing their opposition motions, coming in and saying why you're not entitled to it. So this is very powerful. So you have, now the requirements, you can find this CCP 485.010, 485.010. You need to show in these ex parte situations the danger of concealment. Like you have a defendant and you know he's a shyster. He's got property, he's got an apartment building with $200,000 equity, and you go, we need to attach that. This guy is shifty. He will grant deed that to someone. He will fraudulently convey that to someone to avoid his creditors, and being able to have some evidence of that to show the judge this is a real risk. That property may be impaired is another one. Okay, so maybe they have some property that's going to lose value rapidly. Or if you have some other circumstances where you can show irreparable injury, okay? So keep in mind the powerful tool to be able to go in ex parte in a financial elder abuse case. So sometimes these are things that you can bring up. Sometimes it will provide leverage for an early settlement of a financial elder abuse case, something very important. So then we have the hearing, okay? Let's switch pens again. We're going to keep you color-coded here. We're going to switch to the brown. You're going to have the hearing on the motion. That's the day when you've got to be prepared. You've got to hit all your points. You've got to be prepared to discuss your evidence. You've got to be prepared to discuss the property you're seeking to attach. You've got to be able to show the big key here, and I'm circling that, likelihood of success on the merits. You have to be able to show that you're likely to prevail on cause of action for financial elder abuse, okay? It does no good if you can't show that. If it's kind of a weak case and it's he said, she said, and it's kind of iffy, don't expect that the judge is going to grant the attachment order. You have to prove that it's more likely than not you're going to prevail on the success of your financial elder abuse claim, okay? So that is very, very important. Now, just because the judge says, issues the order, stamp, here it is, it doesn't mean that you win the case. The case isn't over. It just means the judge believes that you're likely to succeed. It's the same thing that happens in temporary restraining order cases, preliminary injunction cases. It's the same process. So don't come out of the courthouse saying, I won, it's over. You still have to fight your case on, okay? But you need to show likelihood of success on the merits. If you do that, You get over here to the right to attach order. This is where the judge is filling out the orders. Now, I'm going to point out one thing. So we have your right to attach order. That's great. You may not always get your right to attach order. The judge may say, you know, this is a really close case, and I don't want the plaintiff to be able to attach all this property of the defendants to cover these damages, okay? I don't want to do that, but what I am willing to do is to issue a protective order ordering the other parties not to transfer or dispose of any assets during the pendency of the litigation. So you may not get the right to attach, but you may get them the right to prevent any further subsequent transfers of the property. Okay, so bear that in mind. That's going to be your fallback position in your motion, in your hard argument, law and motion hearing. Protective order may be your fallback, but fight for your right to attach. Fight for your right to attach. If the judge absolutely doesn't want to go for that, be thinking the protective order, okay? So those are your things. Now, if the judge issues the attachment order, the right to attach order, you need to be posting a bond. Now again, this is something that the judge should be requiring you to post. If the other parties are arguing these cases, they should require the statutory code CCP 489.220, 489.220, $10,000. $10,000 right there, okay? Judge can make it more. Now the bond is just in case you lose and you're wrongfully attaching and it causes damages to one or more of the defendants, they can seek to recover on the bond. So you have that. After you get your attachment order, you take it over to the sheriff. The sheriff does the levying, and once the levying is done, and maybe this is where they got the song, drove my Chevy to the levee, but I don't know. I'm joking here, but anyway, you got your Chevy, your sheriff, you've got your sheriff levying. There may be a fee for the levy. Once attached, notice of attachment filed with the court. Okay, so that's a quick and dirty overview. I don't mean quick. It probably took me about 17 minutes there, but that's a good, helpful overview of financial elder abuse, the powerful tool of the Writ of Attachment under the Welfare and Institutions Code. If you need a financial elder abuse lawyer for your real estate cases, some wrongful dispossession of cases, gouging in mortgage and commercial residential transactions, give us a call. We're happy to take a look at your case. Oftentimes, we can take your case on all or partial contingency fee basis. So give us a call. We have flexible legal fees. You can find out more information at seniorcareattorneys.com. Oh yeah, and don't forget to subscribe to our YouTube channel by clicking on the red box, so you can keep these free updates coming to your real estate box, your inbox, your email box. Okay, Attorney Steve Vondran, thank you for listening. Feel free to share this video on your social media networks. Have a great day. We'll see you again.